I'll see myself. Good afternoon, everybody, and welcome to our second claims close-up session. Some of you may have joined us for our first one when we launched a few months ago. And the thinking and view behind this was really that we wanted to give our claims experts a session or a platform where they can really unpack some of the more complicated claims. So really looking forward to today's one. The topic for today is, of course, DNO. When is a director not a director? So we're going to be having some discussions around capacity over there. Today's session has been accredited with 1.5 CPD hours, so you can look forward to that as well. All right, so I'm going to hand over now to Anton Meyer. He is the business head of claims at SHA. He's going to be doing a brief intro of the session as a whole before he hands over to the panelists. Over to you, Anton.
Thanks, Nani. Appreciate the intro. Guys, thank you very much for taking the time to join us today. And I just want to welcome all of you. And hopefully, once we've gone through all of this, it'll add some value to the services that you provide to your clients and gives you some actual real benefits. So I think, as Nani mentioned, I'm Anton Meyer. I head up the claims here at SHA. But please, it's not that impressive. It just simply means that I can get in deeper trouble than anyone else. So the intention of these sessions is simply to share our experiences, because I think, it's quite clear when claims, after all, is where the rubber hits the road, and that's where a client sees the tangible benefits of having insurance. So we believe that sharing those experiences will assist you greatly in the services you provide to your clients in turn. In today's session, we're going to take a little bit of a deeper dive into some of the technical DNO issues, and specifically some of the definitions, and also in which capacity a director must act in order to be indemnified in terms of a DNO policy. We will also be touching on, towards the end, some practical examples and guidance as to, where to notify certain claims, how to consider those as well, because you don't want to have a situation where a claim is notified to the wrong policy, and at the end of the day, there's a potential problem either on your side or on the insured side. So we will certainly, try and provide you with some practical guidance there. Just some, from a practical perspective, please just utilize the Q&A tab at the bottom of your screen. I'll monitor the questions that come through, and we will obviously try and answer most of those questions during the session. But of course, as is always the case with complex lines of business, some of these answers might need a little bit more thought, and we will then respond to those queries next week or so. But we will definitely get back to you. So please feel free to put those queries in the Q&A tab. I'm going to hand over to the team shortly. It's Pia and Colin. They're both senior financial lines claim specialists. And then, of course, Chris, thank you very much for joining us. Chris is the legal director at Clyde & Co. And he'll also be sharing some of his insights with us on things that they've seen, some of the international experience, stuff like that, to just give you some clear guidance as to where things are going to go or potentially go within the South African market as well. I really hope that you find this interesting, but if I could maybe just ask if there are any other topics, any other claims topics whatsoever that you believe we should spend some time on, please feel free to let me know. My email address is anton@sha.co.za. So, and what we'll do is we'll just work that into future sessions, and hopefully that will also, then assist yourselves with more information in order to do your jobs even better. But thank you again for joining us, and I sincerely hope you're going to join the time with us. And with no further ado, it's over to the team.
Thank you, Anton. So I'm Pierre. I think let's start at the beginning. Colin, can you walk us through what the main elements of a DNO policy are? Colin, I think you are muted.
Okay, there you are. So that's the technical issues done for today. Thanks, Pierre and Anton, for that introduction. And yes, hopefully we're able to shed some light with everybody on this issue of when is a director not a director. And we're starting with some fundamental principles that we need to look at before we can move on to the more complex discussions that we'll be dealing with later. So the first matter that we need to look at when considering a Dno insurance liability policy is the indemnity clause. And they usually contain the following main elements, and that is insurers will pay on behalf of the insured person a loss resulting from a claim first made during the period of insurance. There's two other elements that need to be looked at as well, which is the wrongful act, and the person, it has to be committed while acting in such capacity. So these are the three main elements that we're going to be taking a look at: insured person, loss and claim, as well as the wrongful act elements and the capacity element.
Colin, you mentioned that the cover is provided to an insured person, but that has a deeper meaning. Who is an insured person?
Okay, so if you're looking at insured person as per the Dno policies, you'll see that defined broadly to extend to members of the management of the company. So this includes your members of the board of directors, your prescribed officers as per the Companies Act, your members of board committees such as an audit committee, and then also employees, but only to the extent that employees are acting in a managerial or supervisory capacity within the company. So these are the main people that could be defined as insured person, but only acting on behalf of the company in the capacities referred to above.
Thanks, Colin. Chris, do you, when is a director liable, now that we know who directors are?
It's a very good question, Pierre, and good afternoon, everyone. There is an ever-expanding scope for liability of directors, and I think the starting point to ground the discussion is to look at the sources of liability, and we'll come to that. But I thought, before I answer the question head-on, Pierre, it might be useful just to talk about the ABCs of a Dno policy. In the Dno market, traditionally, we have what's called Side A, B, and C cover. Side A cover deals with indemnity for a director or an insured person, to touch on what Colin has just said, where they're not otherwise covered by the company, and that may cover them for defense costs and indemnify them against damages. Side B is company reimbursement cover, so where the company pays costs on behalf of an insured person, it can claim those back. And then Side C, which we seldom see in South Africa being triggered, relates to securities claims against a company, so claims by shareholders or holders of other financial instruments. A little bit later in the discussion, we'll come to why that we don't see so many of those. But Pierre, to come back to your question around sources of directors' liabilities, the starting point to understand where directors' liabilities come from is an understanding of a director's duties. A director owes fiduciary duties towards the company, and fiduciary duties have a special meaning in law. A fiduciary duty, or a fiduciary in the context of being a director, is a person who acts in a position of care and trust towards a company, and they must act in good faith in their dealings with or on behalf of the company. And what is fundamental to all of this is the understanding around separate legal personality, in that a company exists separately as a juristic entity from the people who control it, its directors, and its shareholders. That is an essential principle of company law, which goes right back to the 19th century, and is a fundamental protective mechanism for directors who wish to exercise that role because of the legal protection that it gives them. So when we speak about fiduciary duties, those are duties which must be discharged by the director following the law in terms of the Companies Act and the other sources of their obligations. In the case of listed companies, you would look at the King Code, you would look at the JSE listings requirements to define all of those duties. And then you would also look at any sector-specific legislation. So using the example of a director of a mining company, there is obviously a raft of mining sector-specific legislation, which will define how a director is required to conduct themselves in that sector. So in terms of sources of liability, really, Pierre, a breach of any of those elements by a director in the discharge of those duties could be considered a source of liability. But the most important sources of liability that we see in dealing with DNO claims that come through litigation is in breaches of the duties set out in the Companies Act. And for those of you who have any sort of academic interest or wish to read further, or if you can't sleep at night and wish to put yourself to sleep, those are set out in section 76 of the Companies Act. Those are the codified duties of directors. But in saying that, it's not to say that they only came into existence when the Companies Act was signed into law in 2013. Those duties have been around for a long time in our common law. They've just been set out nicely in section 76. So hopefully that answers the question, Pierre, but I'm happy to go on.
Yes, no, it does. Thank you, Chris. So now that we know what the duties are of directors are, to whom do they owe those duties? Could it be shareholders?
Well, that's a loaded question. The main answer there, Pierre, is that they owe their duties to the company. And it comes back to that point that I made around separate legal personality. It is difficult, I think, as a general feature to try and understand the dynamic between directors, shareholders, and the company. But the best example that I can give, and one which many of you may be aware of in the last few years through the media, is the Steinhoff situation, where there was a massive, extremely complex fraud perpetrated by management of Steinhoff, led by Marcus Jooste and several other of his merry men on the board. They hoodwinked their auditors, they hoodwinked the market, they hoodwinked seasoned and experienced captains of industry in South Africa. And that led to a great many disappointed shareholders and a great many threats of litigation by shareholders whose holdings in Steinhoff had plummeted once the fraud was discovered. There was an attempt in this country to litigate and to put together a shareholder class action to take on a number of the directors who were implicated in the alleged fraud, as well as the auditors, Deloitte. And that case served as an interesting litmus test to answer your question as to whether directors owe duties to shareholders. So the classic answer that I might give you as a lawyer is, it depends. But I'm going not to take the easy route. I'm going to say, as a general feature, directors don't owe duties directly to shareholders. They owe duties to the company. If those duties to the company are breached, then a shareholder may have a claim, but they have to follow a certain process to vindicate that claim. There's a process set out in the Companies Act, which we can come to in a moment. But in discussing these topics, I often like to use a rugby analogy. And in bringing a shareholder claim against a director, one must be careful not to join the ruck from the side. You need to bring your claim in a certain way using what is called a derivative action. And if you do that in the right circumstances, then you may succeed. So it's a long answer to a short question, Pierre, but hopefully that kicks off the discussion. I'm sure we'll go further on that.
Yeah, it does. Why do you think, or why is it in law that that the claim doesn't lie in the hands of the shareholder, but the company?
Because firstly, Pierre, it creates the potential for limitless liability and for a multiplicity of actions by separate shareholders for the same wrongful conduct of the directors. So it erodes that legal protection that comes from being a director in a company, that fundamental pillar of separate legal personality. And if it were to be the case in our law that shareholders could bring actions through a fairly wide process, then it would serve, I believe, as a strong deterrent for directors to accept office. So there's a very good reason in law why it's not so easy to bring a claim wearing your hat as a shareholder directly against a director. But given what I just said, it's not impossible. One must just follow a particular process.
Yes. Yeah, no, I'm with you. Thank you, Chris. And that also those judgments also codify our belief as insurers of the risk that we underwrote. So if every shareholder could bring a separate claim for the reduction in value of a share, that would, yeah, as you said, bring about limitless liability. So thank you for that answer. Do you think, or are there different liabilities for executive directors and for non-executive directors?
It's a very good question. And it's a question where I would encourage anyone who holds a non-executive director position to listen very carefully. In the Companies Act in South Africa, there is no distinction between the duties of executive directors and the duties of non-executive directors. We frequently see in our firm, when we represent directors who are sued for alleged wrongful acts, that non-executive directors somehow believe that they have a lighter set of obligations or a lesser risk of liability because they believe that a different set of rules applies to them. And in law, that is not the case. It may well be that in practice, and particularly when we're talking about listed companies, the workload and the responsibilities of a non-executive director are quite different, and they act in more of a supervisory and an oversight role. But when we talk about those hard-coded duties of directors that sit in Section 76 and in the common law, there is no distinction.
Thank you. But is there not a section in the Companies Act that a non-executive director can rely on to say that he relied on the advice of others in performing his duties?
Now, Pierre, I think you're probably referring to the business judgment rule. Is that correct?
Yes, correct.
Yeah. So that's available not only to non-executive directors, but to any director. And it's a very important defense, which comes through in, I think it's Section 77(9) of the Companies Act. Again, for those insomniacs who are going to go and do further reading afterwards. The business judgment rule is a hugely important protective and defensive feature of the Companies Act, in that it provides for an individual who has relied on the advice of others reasonably. So that may be the company's internal or external auditors. It may be individuals on the board who are more qualified, such as those who sit on the audit committee or the risk committee, that if there was a reasonable basis to rely upon their advice, that provides a defense in terms of the Companies Act. So it serves as a very important measure for a director, and I think, as you make the point, a non-executive director who may not be a jack of all trades, may not know everything about the life of a particular company, or only be assigned to a particular portfolio, that they can rely on the business judgment rule if they are ever sued for wrongful acts.
You articulated that well. Thank you, Chris. So that brings us, I think we have concluded on who an insured is and the duties of an insured person. The next element of a Dno policy is, of course, that the insured person must act in a capacity as an insured person or a director, as it is commonly defined. Colin, what does it mean when a policy stipulates that one must act in a capacity as a director? And what is the difference between a director and, say, an employee?
Thanks, Pierre. This is a very complicated question, and you need to look at the capacity element in some detail so that you can define when a director is not a director, because what happens is people have many hats in an organization, and there's many different roles that a person can play in an organization, and as a result they can wear more than one hat at a time. And this is the crux of the conversation that we're having today. So one of the things to look at, which is quite important, is the distinction between a director versus an employee. So you have definitions to help you to get to the crux of the capacity issue. But broadly speaking, you've got a director as defined by the Companies Act, which is someone who's involved with the business affairs of the company and managed under the direction of its board. So this is a steering function. If you look at a more dictionary definition, you see a director, one who directs, is one of a group of persons entrusted with the overall direction of a corporate enterprise. So this is a steering function. A director is someone who's directing the affairs of the company as a whole. Whereas if you compare this to an employee, for example, they are persons who in any manner are assisting in the carrying on or the conducting of the business, usually for salary or wages and in a position below the executive level. So employees they assist on the day-to-day business and they don't steer the company in that direction. But you could be involved as a director, as we'll see in examples later. You could be involved in more than one capacity while working in a corporate entity.
Can you give us an example of when a person is acting in a capacity as a director?
Okay, so we have a few examples. Some of them have been in the media a lot, and a lot of people will recognize these matters. One of these matters that I thought would be a good one to show, because everyone has heard of it, is a summons that was issued against the director, Ms. Mayeni from SAA. It was brought by Outer and another second plaintiff. And you can see in this instance, the allegations that are made in the summons are particularly against Ms. Mayeni in her role as a director of the company, SAA in this instance. And then when you come to the allegations made against her in these proceedings, you can see that it's specifically aimed at her failing in her duty as a director, and specifically her breaches in terms of the Companies Act, as well as some other legislation, but focusing on her exercise and duty of utmost care, failing to act with fidelity, honesty, and integrity, and to take responsibility for the safeguarding of the assets of the company, as well as abusing the position of a director, intentionally or gross negligence, inflicting harm against the company. So this goes to Chris's point as well. It's the director's duty owed to the company, and it's not shareholder related in this instance. And you can see what they were asking in this particular example was for Ms. Mayeni to be declared a delinquent director. So it's a very nice example of showing a capacity and a claim straightforward brought based on capacity problems. Sorry.
Yeah, sure. As you mentioned, in the capacity as a director, that brings to mind an example of another matter that I was involved in, where the decision was made, could only have been made by directors acting in that capacity. And it involved a matter where a loan was provided to, or by the directors, authorized by the directors on behalf of the company to a related entity. And when a loan is provided to a related entity, the Companies Act requires one to, or the directors to do a solvency and liquidity test. And if they can only provide the loan if after the loan is provided, they will still meet the solvency and liquidity requirements. The sanction for not complying with that is that the transaction may be declared void, and the directors pursued for damages in terms of the liability section of the Companies Act that Chris mentioned earlier. In this particular matter, the business rescue practitioner, obviously the loan caused the company to go into business rescue, and the business rescue practitioner asked or pursued the directors for recovery of the loan provided in breach of the solvency and liquidity requirements. And that is, as I said at the beginning, that only a director can make those sorts of decisions, and only acting in a capacity as director. Chris, do you have any examples to add?
Yeah, Pierre, I certainly do. The one point I would make about the capacity issue, and it forms the rump of what we're discussing this afternoon, is that one needs to look at the substance of what took place rather than the title of the individual or individuals concerned. So the mere fact that somebody is a director doesn't necessarily mean that the functions that they were discharging at a point in time were directorial functions. By the same token, one needs to ask, this is the directors and officers policy. We've spoken a lot about the directors, but what are the officers? They're not military officers, and I can perhaps, through my example, give you a little bit of a better sense of what that means. I dealt with a matter several years ago where a prescribed officer, for purposes of SARS tax compliance of a company, was held to account for certain VAT non-returns a number of years after she had left that company. She was never a director. She was a financial manager of this particular entity, which was a subsidiary of a larger group. And some 3 or 4 years after her departure from the company, she received notice of a tax prosecution in Cape Town relating to these unpaid VAT liabilities. And we got involved in assisting her. The policy responded to that claim because she was an officer in the form of being the prescribed officer for tax purposes. Unfortunately, we were able to resolve that through negotiation with SARS, and she didn't end up going to jail, which was what was threatened. But that gives you, I think, some idea of the context, and that is a good example of a situation where an employee who conducts a certain role may qualify as an insured person under the policy. Another example, which some of you may be aware of, would be an information officer. Many of you may know about POPIA coming on stream since the 1st of July. There are some fairly weighty sanctions and fines which are contemplated in that legislation. Information officers have been encouraged to register over the last few months, but conceivably it's possible that an information officer of a company who is not a director may equally qualify for cover on the same principles.
Thank you, Chris. Yeah, as you mentioned, those are examples of, like Anton said at the beginning, it's not the title, it just means that you get into deeper trouble than anyone else. So thank you for that. The other way to look at or understand the capacity requirement better is, of course, to look at it from the perspective of or examples of what capacities are not covered. And one of them is that when a director, and you find this usually in smaller commercial size firms, is when a director provides his own personal assets as surety for the debts of the company to get a loan or whatever the case may be. And in that instance, no one other than the owner of the assets may give surety over it. And that is the person in that capacity. It is not because you are a director. And that is an example of where one is not acting as a director. Colin, can you help us with another example?
Sure, thanks, Pierre. So this is another example that I thought is good to illustrate the point of the capacity issue when a person is not a director. So this is a summons that took place with the SARS versus male and guardian, as well as 2 individual employees or journalists of male and guardian that were listed. So what we're seeing often in practice is a lot of people assume that just because a person is named in their personal capacity that the policy is going to respond. And that isn't always the case, because it's important to look in what capacity the person was actually acting in. And this is an example that illustrates that point, because the male and guardian and the 2 journalists were sued for defamation, and they specifically, it says in the summons that the 2nd and 3rd defendants were at all material times acting within the course and scope of their employment with the 1st defendant. So it doesn't really matter whether or not the 2nd defendants named in their personal capacity were journalists and directors, even if they had the title of directors. What's important is to look at the cause of action that's been brought against the particular persons in their individual capacity. And this is an example where it's a journalist. They published they wrote an article in a newspaper. It was published by the Mail and Guardian, and the claim against them is for defamation. And this is a claim for their day-to-day workings in a company. It's not their role as director. It's not a steering capacity that they've been sued in. So, yeah.
Thank you. And a further angle that one can approach to unpack the capacity requirement and gain some insight into the underwriting intention is to look at exclusions and what is not covered by the policy, or which capacities aren't covered. And one finds typically in Dno policies a bodily injury and property damage exclusion. And an example of how that applies is a matter that I came across recently, is where a operations manager of a lifestyle estate was confronted by a homeowner about the application of certain of the lifestyle estates rules. They got into a debate, and it eventually ended in an alleged assault. And in that instance, the operations manager wasn't acting in the sense that he was giving direction to the company, but he was acting in his personal capacity because it wasn't sanctioned by his employer. So that stands separate from the case where the employer might be vicariously liable for his actions, but it still doesn't mean that he acted in a capacity as a director. The other exclusion that one finds typically in a Dno policy is a professional indemnity exclusion. So that is for claims made by third parties alleging a breach of professional duties. So that would be like when a chartered accountant who is a director of an auditing firm performs functions and audits a client, and the client lodges a complaint to the South African Institute of Chartered Accountants alleging that the technical standard of the audit was non-compliant. That is an example of where the person was acting in a professional capacity. I'm sure Chris can also think of a few examples regarding professional indemnity exclusions.
Yeah, that's right, Pierre. One observation I would share about the exclusions is that they don't exist for no reason. They exist because generally these relate to claims that are more appropriately insured under other types of policy. So if you view your suite of corporate insurance protection as a suit of armor, you would have the PI policy as your breastplate. You would have the Dno policy as your helmet. You might have a cyber liability policy somewhere as your gloves or something, but they all fit together. So the exclusions are designed to make sure that in these instances, a claim lands against the right policy. And that ties back to what Anton said at the outset of the discussion. In the PI context, I mean, one obvious example that is always top of mind for us is that as a law firm, we sign off on opinions all the time, and generally the opinions that we send out are signed off by a director. So I may issue an opinion to SHA, advising on policy response for a particular claim. If it turns out that my advice is wrong and that I haven't done my job properly, and SHA decides to sue me, or at least sue our firm on the basis of that advice, then that will not give rise to a director's liability claim as a general feature, even though when I signed that advice, it was signed in my capacity as a director, because the advice is being given in a professional capacity, and it really is a PI claim. Maybe slightly different if I had gone rogue, if I had not followed internal protocols, if I had ignored corrections to the advice which one of my colleagues gave me, for example. But generally, it illustrates that even though I may be signing it off with the title director, it is professional advice and it should be a PI claim. And these issues often come up with auditors and accountants as well.
Yeah, that it makes a good point that you're not giving direction to the law firm while signing that off. You employ, or you basically fulfilling a function as an employee, although at the senior level. You mentioned a few elements there of vicarious liability, and I referred to it earlier. Would you mind expanding a little bit on the when an employer may be vicariously liable for the acts of his employees?
Yeah, sure. So vicarious liability allows for liability on the part of an employee or representative of an entity, for liability to be imputed to the entity on the basis of what they have done. So a classic example may be a delivery driver who is out doing a delivery on behalf of your company. In the course of that delivery, they knock over a child, and there is a lawsuit for the child's injuries, which were committed by the delivery driver, but in the course of carrying out a delivery. In that situation, the legal inquiry would be whether the employee was acting in the course and scope of their employment. If so, as a general principle, the employer may be held vicariously liable for their actions. So it allows for almost a through pass of liability if the conduct of the employee is sufficiently closely related to the business of the employer. There is a distinction, and we often have to make this distinction in fidelity claims, where an employee is off on a frolic of their own, is defrauding the company, or is doing some other, is up to no good outside the scope or bounds of their employment responsibilities. And in that situation, it may be much more difficult to hold the company vicariously liable for the acts of the employee. There are a lot of decisions on the law of vicarious liability, for example, in relation to security companies and security guards who shoot people or accidentally kill people in the course of responding to security incidents. So that's a classic example of the vicarious liability conundrum.
Yeah, and I'm sure very applicable in the public liability space. So I'd leave that for the colleagues in that area to discuss, which they have done in the previous close-up session. But on to the next element of a Dno policy. Now that we know that, or we've established who a director is and in what capacity a director should act to enjoy cover under this policy, let's look at what cover is provided by Dno policies generally. It is usually in this in the context that cover is provided to for damages. So where a claim is made against a director when he did something wrong, and there's a damages award against the director, that the policy will typically indemnify the director for those, including settlements, and if there's a cost order against the director. It would also provide for defense costs, which would include legal fees and other professionals that may be required in putting up a defense for the directors. And it is also important to note what is not covered, and that is things that are like criminal fines or criminal penalties or any other matter deemed uninsurable under law. And it also does not provide cover for taxes or employment-related benefits that an employee or a director may be held liable to return. We'll come to the conduct exclusion a bit later in the context of a wrongful act, but just as a general principle, this is the covers provided under, as Chris mentioned, the side A of a Dno policy. Then the next element of a Dno policy is that there must be a wrongful act. Colin, can you explain what a wrongful act is?
Thanks, Pierre. So a wrongful act is basically defined in the policies as an actual or alleged wrongful breach of duty, error, omission, a misstatement, or a misleading statement, and importantly, in their capacity as an insured person. So here we're seeing the capacity element again, and we have discussed the elements of a wrongful act earlier with Christopher, but most of the wrongful acts will probably stem from breaches of the Companies Act, specifically Section 77, which is according to the principles of common law relating to breach of fiduciary duty or any loss or damage or cost sustained by the company as a consequence of any breach by the director. And then you can have the common law side of wrongful acts as well, which is again your fiduciary duty, and that's without limitation. It's avoiding conflicts of interests, not exceeding the company's powers, and accounting for secret profits, and looking for the best interests of the company. So that's the fiduciary element is older, and it's now been codified in the Companies Act.
Yes, thanks, Colin. Back to the so yeah, from that definition, the wrongful act is defined quite widely and includes criminal actions and either willful or intentional acts which are typically uninsurable. And if we look at the conduct exclusion that typically applies in Dno policies, the origin is that, so we know that we cannot insure someone for willful acts or where he derives profit, and this applies to directors as well. And but at the same time, just because it's alleged doesn't mean it's true. We have this principle in South African law, and I think most other Western countries, that a person is deemed to be innocent until proven guilty, and that he has the ability to provide or to put up a defense against allegations. And as we've seen from our own experience, defending against those allegations, even if it's untrue, it costs a lot of money to defend against those. And that is the purpose of this policy. So as long as there is no final judgment or an admission by an insured person, that is what Dno policy will do, is provide defense cost cover for the directors. But for insurers not to overstep and breach the insurance laws which regulate them, there's a provision that if there is a finding that the director was acted in a manner that's not insurable, then the benefits received under the policy should be returned immediately. And that is the central concept of DNO cover is this defense cost cover. Even if there is a criminal prosecution against the director alleging that he did something wrong, acting as a director, then that is where the policy will step in. That brings us to the close of that element. The next element is of a DNO policy is a claim. There must, as a natural course, be a claim against the director before the policy can do anything. What forms may a claim take, Colin?
So Pierre, it's quite broad and you don't want to limit it, but an example of what a claim is in terms of a DNO policy, it could start with a written demand, either seeking compensation or an equitable remedy. It could also be civil proceedings, so a summons, a regulatory proceedings, statutory or administrative proceedings. It could be an element of a criminal proceedings where the director has been arrested or charged. And there's also mediation, arbitration, and also counterclaim. These could all be claims as defined as the policy. Just note the requirement that it must be brought against an insured person in their personal capacity again.
Yes. Chris, have you seen like the sources of DNO claims? You mentioned it earlier, but like, is there a particular area where claims are made against directors?
Yeah, Pierre, I think that the greatest source of claims made against directors is firstly from the company itself. So where there is a director gone rogue, who has acted contrary to the interests of the company, made a secret profit or taken some advantage for themselves, then there may be a case like that. To give you an example of a matter like that I handled a few years ago, we had a situation where there was a managing director of a securities brokerage, a stockbroker, who had traded on a personal staff trading account in certain derivatives, which then went bad in the 2008 financial crisis, as a result of which the company had to meet the margin calls on those trades for significant amounts of money. So the director had been trading contrary to the interests of the company, had defaulted on his trades, and the company had to step into the breach in order to make good the losses. The company then sued him for breach of fiduciary duty and to recover those losses. So that's a classic example of that type of claim scenario that I mentioned. Another very common source of claims against directors is from employees. I'm not going to stray too far into sort of employment practices, liability type things, but it is something we're seeing more of, particularly as we are in a higher risk environment in terms of sexual harassment claims, for example, the Me Too movement. Less so in South Africa, but certainly in the United States, there have been a huge number of claims of that type made against directors and some very high profile individuals. So those are just two sort of typical examples of sources, very common sources of DNO claims.
Yes, that's insightful, Chris. I think that is a peculiar element of DNO policies, is that it is taken out by the company, being the policyholder, for the benefit of its management. And for individuals without much knowledge of DNO policies, sitting on a board of directors, as an example, you see that we pay large amounts in premiums to, or not so large amounts, but payments of premiums to for this DNO insurance. And then when you have an issue with a director, you'd find that the policy protects the director when the claim is made by the company. So that is, I'm not aware of many other types of policies where you encounter that scenario where the benefit of the policy is for the person that you are pursuing. So yeah, thank you for bringing that example to us.
Yeah, Pierre, one other thing that I'd like to mention on that is that you're right, it is a peculiar feature of DNO policies, and it's something that's often misunderstood. So when I spoke earlier about the ABCs of DNO, that misunderstanding often takes root at the time a claim is to be made, because there may be a fallout between the company and the director, but that individual is still entitled to cover under the policy because it's been taken out for their benefit. And in most cases, even if they have breached their duties and acted wrongfully, the defense costs wording of the policy will give the individual the benefit of the doubt until it is established by a final adjudication that they have done wrong. So I'm sure you'll come back to that when we speak about the conduct exclusion in a moment, but it illustrates that slightly strange setup there. I also just wanted to touch on one other point, which is that there are examples of claims where that misunderstanding has come through in how the claim has been presented. And it goes to the timing of notification of a claim, which is very important. We encounter situations quite often where insured persons don't know that the policy exists for their benefit. And there is then a notification issue. We've seen it, for example, with many of the individuals involved in the Zondo Commission, who were directors of state-owned entities, stepped off the boards of, or were removed from the boards of those companies, and then get called to testify in the Zondo Commission. As a general principle, they are entitled to cover under the DNO policies of the entities concerned, because in many cases, a DNO policy will provide either limited or lifetime runoff for retired directors if they retired rather than were removed. An issue that's come up in a great many of those claims is late notification, because the insurers haven't been told. A whole load of work is then done in the defense of a claim, and it then becomes quite difficult to unscramble. So a practical tip is, if you are part of a company, if you've taken out a policy, the directors should know about it, and should have some idea of how the policy works, so that if the unthinkable does happen, they are able to notify a claim, or at the very least, get in touch with the broker who can then provide them with assistance.
Yeah, yeah, that is very useful. Thanks, Chris. And do you think, yeah, that is excellent. So I'm thinking of a matter that you and I were involved in at some point, where the director applied for or failed to implement a system to pay the monthly life insurance premiums to the life insurer, and where the employee was held liable, or the employee's family that subsequently passed away held the director liable. Can you expand on that example for the benefit of the audience?
Yes, Pierre, I remember the matter. Thanks. That was an interesting example of a claim that didn't quite fit with the DNO policy. And one had tremendous sympathy for the individual involved, because he was caught between a rock and a hard place with the interests of the company and in this claim that had been brought. But basically what had happened is that an employee of this company, was a manufacturing business, had been subject to a group life sort of scheme. The employee passed away after being medically boarded for a period of time. And when the family went to present a claim, to a life claim to the scheme, they were told that the premiums had not been paid for the last 2 months by the company, and the claim was therefore rejected. So they then brought a claim against the company, and the company in turn attempted to trigger the DNO policy by holding responsible the financial manager who oversaw the payroll system. Now, in the investigation of the facts, it turned out that the individual through whom they were trying to trigger the DNO policy had not been responsible for setting up the payroll system. He had no idea that the right box had not been ticked to facilitate those payments. And I seem to recall there was an issue with a software upgrade or something where a setting had changed, but it was completely, there was nothing deliberate in what he had done. And from a capacity perspective, it simply didn't fall within the scope of what a DNO policy would pick up. So as I say, we had tremendous sympathy for the individual involved, but unfortunately, because the company had tried to contrive a claim against him to trigger the DNO policy, that claim, I think, was ultimately rejected, if I recall correctly.
Yes, yeah, that makes sense, and that is a typical example of where companies, either because of misunderstanding or out of desperation, try to fit matters that should fall under other policies or simply not insured, and try to force it under a DNO policy. And that is one of the things that we encounter from time to time in the DNO space is because it is so wide, like the cover that is provided, and it's not a specific risk, it's just described in which capacity and the type of action that must occur, that you do get these opportunistic type of claims. So yeah, that is from our experience. What I think of another example that you mentioned to me previously, Chris, is like the what happens when in a motor dealership, as an example, the dealer principal fails to follow the internal protocols that leads to a loss to the company when buying motor vehicles and that type of scenario.
Yeah, Pierre, that was another one where you and I campaigned together. If I recall the facts correctly, you're right. It was a dealer principal of a motor dealership who had purchased a vehicle on a kind of motor industry deal. He had unwittingly been hoodwinked or defrauded in that transaction, had paid for the vehicle on behalf of the dealership in the expectation that it would be delivered, and it turned out to be a fraudulent scheme, and the vehicle wasn't delivered. And the holding company of the dealership then attempted to institute a claim against him in order to trigger the DNO policy. They were effectively looking to the DNO policy to pick up the tab for the loss of that vehicle. And the unfortunate misunderstanding there was, I suppose, in understanding how the DNO policy would respond. So the advice I think that we gave in that situation was that there was not a basis to reject the claim outright. The dealer principal in that situation was perfectly entitled to a legal defense of the company's claim against him. Because remember, a DNO policy exists to provide two things. It exists to provide defense costs and investigation costs if an insured person is held to account. And if they are ultimately found to be responsible for wrongful conduct, then the policy may indemnify them for damages. But the defense costs comes first. So the advice that we gave, I think, in that claim was to say, yes, this may be a claim, but if it is, then you need to pursue that claim against the individual, and he will be defended under the policy. And it unfortunately put him in an extremely difficult position, because the company then needed to find some way to effectively litigate against their own employee, but they'd never gone out to do that. They never intended to do that. They wanted to trigger the DNO policy, and they thought that it would simply be a situation where the policy paid the value of what was lost, like an assets insurance policy would. And that's not how it works, because of course, in a liability policy, legal liability needs to be established in order for the policy to respond. So in a nutshell, if I remember the facts correctly, that's what happened.
If
Yes.
I can just jump in, I think, Pierre, Chris, that I think is one of the best examples that we can actually put on the table. In someone wearing two hats, as Colin mentioned earlier, because strictly speaking, in this under these facts, this individual was acting as an employee when he did the deal. Okay, but when the claim was made against him, the allegation was that he failed in his fiduciary duties by not checking and doing this deal wide of the protocols in place. So this is a very, very good example of how difficult and how one set of circumstances, one action, could lead to one portion of the claim that's not covered under Dno policy, and it could maybe have been covered under the assets policies or something like that. But then, of course, the other side of it, which is the allegation that he was acting in that fiduciary capacity or in a management capacity. So it's actually, this is exactly, and I know we tend to get way passionate about this, and we apologize to the audience, but this is what we do every day, and sadly, we love what we do every day. So, but it's very clear here that there's one portion that's absolutely not covered, and then the allegation is made based on exactly the same actions, and that leads to a potential claim in terms of the policy. If at the end of the day, even if the employer or the owner of the company proved that there was a breach, but the breach was not committed as a director, it was committed as an employee, which is probably where this matter would have gone. And from what I recall, you would sit with a situation where we would pay the defense costs, we would defend that individual as not having acted as a director and pay the defense costs. But if he was then found liable later as an employee, that's a whole different set of circumstances. Then you start moving into the realm of employment legislation. So that's why it's so important for us to be very careful when we look at all these things, because everything is so intertwined, especially under the Dno policy. You've got from labor, tax, all of that stuff that we have to consider. So, and that's specifically why, and I'm glad you guys brought up that example. This is exactly why we thought capacity is such an important topic for us to discuss. So thanks for that, Giles. That's actually, but as I said, I apologize to the audience. We like this type of stuff, and we can probably talk for 4 days just on one matter, but that is a clear example of just how things can change overnight. But yeah, my 2 cents worth.
Thanks, Anton. I think we've discussed a few examples, and if there's time left, I think we can circle back to a few more. But I'm sure a lot of our attendees joined for the meat of it, and what are the practical tips that we can offer when dealing with these Dno claims, and specifically this difficult capacity debate, which, as you now know, is very dependent on the facts that we've shown, and specifically the last 2 examples, is that everything turns on the facts. So it's difficult to give rules of thumb, but we'll try nevertheless. The first one is for the policy to respond, the claim must be made against an insured person. So we look first, is there a claim against the director? Is he personally named in the claim, in whichever form it is made? And if he is so, and as we've seen, if he's personally named, it doesn't mean necessarily that the Dno policy will respond. But the second thing one can do is, after looking if the person is personally named, is to read through the allegations, what is alleged, and can we discern from that whether the director is acting in a professional capacity. One area to look out for is it in a professional services firm, because then that distinction becomes important and more likely to occur. And to look at other potential capacities in which the person may have acted. I mentioned the operations manager of a lifestyle estate earlier. And so the question there would be, okay, so this allegation is made against the director. He was at work while it was happening. Then one can ask, did he give direction to the company, yes or no? And if he wasn't giving direction to the company, one could ask, is the company maybe vicariously liable for the actions of the operations manager, and that would give you a good idea of which policy to notify. Is it the professional indemnity, public liability, or the Dno policy? And I circle back to it all depends on the fact. So if you are unsure, it is also a good idea to, or good option to phone one of us and ask what our initial thoughts are on the facts that are known at that stage. Anton, I'm sure you have a few practical tips as well.
Thanks, Pierre. Yeah, I think, I think, based on what we've discussed so far, I don't believe there's any silver bullet and checklist that one can tick to make sure that you do the right thing. I think at the end of the day, the safest is, as you mentioned, Pierre, to engage with us or to engage with the relevant insurers and just double check, early on in the process. I think, the one thing, practical tip that I can definitely put out there is don't wait for 2 years, for the one or the other to be rejected, and then try and notify the claim to a Dno or to the liability policy or to the PI policy. It is always better to rather be safe than sorry. At the end of the day, whoever the Dno insurer or PI insurer, whoever is, will look at the facts and then either reject that claim or accept it. But it's very difficult to go back a couple of years later and say, oh, the PI claim was rejected, here's the Dno claim. And once again, there is no silver bullet. I think the practical pointers that you've put up there, Pierre, is quite important, and it's quite relevant. But I think, where you have a situation that, argument's sake, the managing director of an engineering firm sits in front of clients and says to them, yeah, of course we can design this bridge for you. And he then makes certain concessions, he makes certain confirmations and undertakings and promises. And now you're sitting in a situation, was that professional advice, or was that effectively linked to him acting as a manager or acting as guiding the company and in that capacity? So it's really, it becomes very, very difficult to, at the outset, to be able to say, yes, it's liability, yes, it's PI, yes, it's Dno. And the best advice from my perspective when it comes to this type of scenario is to rather engage with all the potential insurers and find out where it actually sits. Sometimes you're going to end up with a situation that is probably going to be, at least for the first couple of months, while you're still obtaining information, investigating, looking at all the contracts, looking at everything that's happening, where you're still not going to be 100% sure. There is no way that anyone can say to you immediately out the starting blocks, this is definitely Dno, this is definitely PI, this is definitely liability. There are certain factors, if someone got injured and it's a third party and like the example you mentioned, that one's reasonably clear that, the individual couldn't have been acting in a managerial capacity or in a director capacity when he allegedly assaulted a third party. That was reasonably clear. But where you have a situation that, certain promises were made, the question then is, it's a factual legal question, whether that individual was acting in a fiduciary capacity or whether he was acting in a professional capacity. So it's better to rather engage with the insurers and, then decide where to go from there. Because if the claim's notified and we still don't know where it is, at least someone is there working with you as the broker and with your client to figure out where this claim should actually sit. So that's the only real tip I can give, because for the rest, I think, the closest we can get is the points that you put up there. But, lots of times, and you guys can back me up on this, we have, especially in the past couple of years, we have seen so many summonses where, for whatever reason or for whatever claim, the individuals are being joined to that specific action. Now, if it's in a PI scenario, an employee is also covered, the PI policy will pick that up. The employee is not excluded. If it's a Dno issue, of course, the Dno policy will pick it up. If it's a liability issue, once again, the company could be vicariously liable, And at the end of the day, the company, in certain circumstances, must also protect their employees, and will therefore it'll become a claim under the public liability policy, for instance. So it's just very, very important that we keep those things in mind. So yeah, but as I said, rather engage with us or engage with the attorneys, but early on in the process, before we are 2 or 3 years down the line, and then there's nothing to be done.
And so from my understanding, Anton, but you would know better, is that these policies are generally it's mutually exclusive. It's either covered under one or the other one. It's not.
Yes.
It cannot be covered under both.
Yeah, no, 100%. I think, look, the only place where there could be a bit of an overlap is between a DNO policy and, argument's sake, an EPL policy. Where both employment practice liabilities are covered. But once again, there we will have to see, insofar as the summons is concerned, whether it's a specific claim against the director or whether it's a claim against the company and the director is just named. And of course, there's a more specific insurance for EPL if there is an EPL policy in place. But why I mentioned that example is where there is no EPL cover in place, the individual director could have a defense, but the company then sits without cover. And that is where things become a little bit disjointed. And this ties in with what Chris was saying earlier, where all these different policies is all part of your corporate armor. And I like the analogy. Actually, it makes sense. But you don't want to have a situation where the director gets the defense costs, and you end up with a situation where the director maybe was acting willfully, intentionally, and all of a sudden, the moment it's found that there was that willful intentional action, which of course we can't indemnify the director against, that the claim then could go back to the company as a vicarious liability claim. So it's that important. It's not that the DNO policy automatically just covers EPL. It is still subject to its own terms and conditions. And you could end up with a problem where the company, at the end of the day, has no cover whatsoever. And of course, when a claim is excluded under the conduct exclusion, it's against the public morals for us to indemnify the director, and we will try and recover our costs for those excluded claims. So yeah, I think that's maybe one of the only examples that I can think of where there is sort of dual cover. But if it's more insured or better insured under the company policy, that's obviously where it will go first. And the only place where there could be something like that is if the director is personally held liable, and, argument's sake, it was certain negligence issues or whatever, the DNO policy could respond rather than an EPL policy. But for the most of it, it won't work that way. There's possibly certain duplications insofar as the defense costs are concerned, but that's simply because the defense costs are there for the director and to make sure that it's as wide as possible to protect the directors, for the legal defense. But that is actually, it doesn't really, it's not really an issue because it, strictly speaking, is mutually exclusive, all depending again on the facts. So, once the facts are clear, it's either covered under one policy or the other, if that answers your question. Yeah.
It does. Yeah. Thank you, Anton. Let us, as a wrap up, I think those are good practical tips. And I mean, the alternative is always to notify both policies and just expect that it might be rejected or likely rejected under one if it's mutually exclusive, as one of the scenarios that Anton discussed. Let us look at sort of historically. Have you seen any claims trends, Chris, in the last or in your practice at least?
Yeah, I certainly have, Pierre. I'd say the overriding DNO claims trend in our office in the last 3 years has been state capture. There are dozens of claims that have related to the Zondo Commission, the Nugent Commission in relation to the affairs of SARS, and similar inquiries. So many claims for directors of state-owned enterprises. And I think that has driven, perhaps in part, the hardening phase that we are seeing in the South African market. There is also, I think, a general shift in the South African corporate environment towards individuals and companies being more litigious. There's greater access to litigation funding, so that's definitely part of it. And there is also an easier way to get a shareholder class action, for example, certified. So when I spoke earlier about the joining the ruck from the side analogy and all of that, I said that it isn't impossible in our law for a shareholder to bring a claim against a director, provided the right steps are followed. I just want to circle back to that point as a trend. That is something called a derivative claim or a derivative action. Again, for the insomniacs, it's provided for in section 165 of the Companies Act. And there are a couple of examples we've seen in the last 6 or 8 years of shareholders trying to do that since the Companies Act came along. There was one, I think, involving the Lewis Group, the furniture company, which was ultimately unsuccessful, but there have been 1 or 2 others. So the overall shift in terms of a more litigious environment, an environment in which people are more aware of their rights, is something to look out for. And then the one other trend which I would mention at the moment, or say as a historical trend rather than a new frontier, given the economic situation in which we find ourselves, is around insolvency scenarios. So directors being called to Section 417 inquiries under the old Companies Act, or to liquidation insolvency inquiries being held to account. One of the examples you mentioned earlier, Pierre, in relation to the solvency and liquidity claim against directors, was brought by the business rescue practitioner of a company that had gone into financial distress. We've seen quite a few of those kind of claims. So that is definitely a trend on the historical side of things.
Yeah, that is interesting. I think on the things that we've seen in our office is the increase of costs, or that we haven't discussed up to this point, is the investigation and inquiry extension. And our focus today was on the damages section of policies generally, but there are also, the cover is also available for investigation. So say when a regulatory authority of some sort investigates the affairs of a company and requires a director to give testimony, policies generally also provide for costs to for attorneys to accompany the directors and advise on what to say and what not to say at those inquiries. And ultimately it's for the benefit of the client, because that can also be very expensive. And to an extent for insurers, but because if those costs aren't provided at some point in the future, if a director says something that while he was unrepresented, it could lead to a claim somewhere down the line, and a claim can then, or a claim for indemnity can then materialize against the policy. So that is a case of where the one hand washes the other hand. Chris, can you walk us through, I see we have a few minutes left, on where you see new risk frontiers coming? Is there foreign jurisdictions that we can rely on to sort of point out the way that we could expect claims from certain areas?
Yeah, they definitely are, Pierre. It's always useful to look abroad, certainly to the United States and to Europe, to see what's going on in their DNO markets. In the last 5 or so years, there has been a massive spike in what they call securities litigation in the United States, which has affected the DNO market. There is more limited potential for that to trickle down here because of the legal barriers that we've already discussed to shareholders bringing securities claims. But it is a big feature. One that I think is far more relevant to us is around climate change risk. And we have already seen examples of lawsuits in Europe against boards of energy companies in relation to climate change targets not being met. And as we push further down the path to net zero and to reducing emissions to avoid a global environmental catastrophe, I think we are going to see individuals held to account. It's interesting in that South Africa is not that far behind the curve on this. We have been involved in several environmental green scorpions type matters where directors have personally been held responsible for pollution to land and contamination of water sources, for industrial emissions. And so that kind of enforcement action in South Africa is a fairly large possibility in the industrial sector. Another big worldwide trend is around cybersecurity. So where you have privacy and data security breaches, ransomware attacks have been a huge thing in 2021. There is a very high possibility of directors who are responsible for organizational cybersecurity being held to account, and that will translate into DNO claims. I've already mentioned the Me Too type claims, which have been a feature of the last few years. Obviously, in the COVID economy, there will be a higher default rate from lenders and insolvency type claims. And then in South Africa, I think delinquency proceedings we will be seeing more of. The Dudumayeni example that was mentioned earlier is a really interesting one. And I posted a link in the chat to an article that Auto had put on their website about that judgment. Dudumayeni has dominated the headlines for all of the wrong reasons. But that case, as a statement of what a director's duties are, is a very interesting and readable judgment. And if you have any interest in the topic, I would say have a look at that article and do a bit of reading about it, because it really sets a benchmark for, I think, further delinquency proceedings and for not only civil society, but also sort of a wide body of stakeholders and companies to hold irresponsible directors to account. Many new risk frontiers to talk about. It's all very exciting for DNO lawyers like me, but certainly lots to think about if one is a director and taking on those responsibilities.
Yes, thank you very much, Chris. That is insightful. Anton, you wanted a turn to speak on potential conflicts for brokers in a DNO scenario.
Thanks, Pierre. Yeah, it's sort of just a closing comment, because I know we only have about 6 minutes left, but I just thought it very important to bring this to everyone's attention. The one thing that we do see from a practical perspective is if there is a potential DNO claim, and as we discussed earlier, the company believes that it's just another policy for the company, and they can just claim against this policy whenever there's some other financial loss which occurred within the company. What one needs to understand is that the insured, as we mentioned earlier, is in actual fact the individual directors, okay, not the company. As a matter of fact, the company in most of these instances will be the third party claiming against the individual director. So what I wanted to just highlight and just warn you guys as brokers, from that perspective, is you must understand that if there is a claim like that, you're going to be in a very, very difficult position. You will not be able to advise the company because they are strictly speaking the third party. And your duty then under those circumstances would be to assist the individual director. So it would be advisable to have a split within your company where someone that deals with the holding company or the insured for assets and for liabilities and for everything else, and someone else then dealing with a claim for that specific director. It's just always very difficult, and if anything goes wrong, we don't want you as the broker to be sort of caught in the middle. So yeah, please just keep that in mind. And yeah, if there's ever any uncertainty, again, please feel free to give us a shout. We will always share. We will always try and assist you guys with what's within our knowledge. Obviously we can't go wider than that. But yeah, we're always willing to help. We're always willing to chat. So that invitation is open. And hopefully, we can be of assistance to yourselves in future. But that's it from my side. Thank you.
Thanks, Anton. I think we have 2 minutes left. Can we, there was a general question on the Q&A, which I think is would be helpful for the audience. There's a question of whether a information officer for purposes of POPIA would qualify as a director or officer in terms of a DNO policy. So we haven't seen from our side any claims. So I haven't had the opportunity to test out the theories in practice. Chris, you had a view on that. Could you share it with us?
Yeah, thanks, Pierre. My view on that is that a properly appointed information officer, so someone who's been appointed in terms of POPIA and may not be a director, would qualify as an officer in terms of a DNO policy for actual or alleged wrongful acts committed in the capacity of an information officer. So if there is enforcement action by the information regulator, for example, that may well trigger such a claim.
Yeah, and I suppose it as we've highlighted, it all depends on the facts. We've seen things that one would think falls within the typically the capacity requirement, and then if you dig further into the facts, it turns out not to be. So yeah, interesting times, as you say, for DNO lawyers and for claim specialists dealing with these issues going forward. Thank you for everyone for joining. I'll hand over to Noni to close out. Thank you.
Thank you so much, team. The time seems to have just flown by. Feels like we just started. I hope that you all enjoyed the session and do join us for the next claims close-up session. We will advertise in the next month or two. Your CPD certificates will be sent to you in the course of next week, so you can look out for those as well. From myself, Notutsugo Mhlungu, the SHA claims team, as well as CN & Co, it's been an absolute pleasure. Hope you enjoy